session, and we have about 1 minute before we get started. So let's spend that time hitting the record button. So welcome everybody. We're gonna get started perfectly on time today. My name is Kerry Sautner. I'm the Chief Learning Officer at the National Constitution Center. And I am very happy about this week's theme all around the Bill of Rights. So we're gonna walk you through the history, then the changes of the Bill of Rights, and then modern questions about the application of the Bill of Rights in our everyday lives. So today we are lucky enough to be here with one of our top scholars, Nicholas Mosvick. Nicholas, would you like to say hello to everybody?
Yes. Hi, I'm Nick Mosvick, and I am one of our senior fellows in constitutional content at the National Constitution Center. And as I say every week, I have both a PhD in American history and a JD, so I am a constitutional historian. But let's not waste any time on me because I think we have a lot to get through.
We do. And Nick, I have so many questions, and our students I know have so many questions as well. So as you guys go through the program, feel free to chime in, share questions, share thoughts and ideas. You can use the chat box or you can use the Q&A. Here's some of the goals that we wanted to make sure we go over in this class. So first of all, what is the Bill of Rights? What is it actually? And why did the framers think it was necessary? Where did the Bill of was there? I should rewrite that sentence. But was there a Bill of Rights before our Bill of Rights at around the Constitutional Convention, a little bit after? And how did they come up with those 10? Like, why is it those 10 amendments? And then what's the role of the anti-federalist? If you don't know what an anti-federalist is, you will by the end of this class. And then how did the Bill of Rights change over time? That's some of our big questions around this. Nick, I'd love to, before we go into the fun poll, I'd love to kind of have you set up the big idea for the class, and then we'll roll into a fun poll. I'm not calling it a quiz because nobody's being tested. Fun quiz.
Yeah, so I mean, we look at some of those goals there, and I think the big idea is going to be attached to that, right? Which is that the Bill of Rights fundamentally is about the desire of the founding generation to write in some of the most cherished liberties into the text of the Constitution is amendments. So that answers question number one, right? We're talking about the first 10 amendments to the Constitution. And we're talking about right after the writing and ratification of the Constitution in 1787 and 1788. And we're talking about liberties like free speech, religious liberty, due process, and rights against search and seizure, things like that, right? We're talking about that basic Charter of Rights. And as we'll get to throughout the discussion, when we talk about that last question, right? How has it changed? We'll talk about the 14th Amendment and why the 14th Amendment is so meaningfully significant in our understanding of the Bill of Rights today, but also in the historic framing of how it changes in the late 19th century.
Got it. So there's big changes on the Bill of Rights front that come right after the Civil War. But let's do a really quick, I'm going to stop sharing for a second. Let's do a really quick poll. And guys, there is a million questions we wanted to ask, but I can only ask 6. So I'm going to tell you what I'll do with the rest of the questions for fun. But let's begin the poll. If you can't see the poll, don't worry. I'll read the questions out loud and you can answer in the chat box. So first question is, how many amendments are in the Bill of Rights as ratified in 1791? 8, 10, 12, or 15? You guys keep answering. Next question, who is the primary author of the Bill of Rights? Was it Thomas Jefferson, James Monroe, Alexander Hamilton, or James Madison? Next question, which right is not guaranteed in the First Amendment? Freedom of speech, freedom of assembly, freedom of press, or the right to bear arms? Fourth question, what is the Third Amendment about? Soldiers occupying your home without your consent, the right to privacy, the rights to an attorney, the rights to a jury trial. Fifth question, this one's harder. Double jeopardy, self-incrimination, and due process are all critical parts of which amendment? Is it the fourth, the fifth, the first, or the eighth? And then the final question for this quick poll, is the original Bill of Rights covered abuses by is it the national government, the state governments, or both? Now, that last one's a tricky one. And so remember, the original Bill of Rights, which would have been 1791, did it cover abuses by the national government, the state governments, or both? So I'll give you 1 more minute. The poll is up. And then Nick, you know what I'm going to make you do. I'm going to make you answer all of these and tell us which one's right.
I thought you were just going to have me answer which is my favorite, which is obviously the second to last question. The hardest question is my favorite question.
Go figure. Okay, so let's start with the first one. How many amendments are in the Bill of Rights as ratified in 1791? Nick.
This was almost a pop quiz because this was seeing if you paid attention to Curry and myself, because the answer is 10. As we mentioned, the first 10 amendments to the Constitution.
Awesome. Yes, we snuck it in there. The next one is the primary author of the Bill of Rights. This one's really hard for our students. Everybody's kind of jumping around which of the answers. So who gets the primary author sash for the Bill of Rights?
So that would have been our Friday guest. That's Mr. James Madison of Virginia.
James Madison of Virginia. Yes. Very good. Last Friday, Nick is talking about, we had James Madison literally from Virginia zooming in.
That's correct. Coming from Williamsburg, Virginia. Yes.
It's really fun. Which right is not guaranteed in the First Amendment? Is it speech, assembly, press, or bear arms?
That's going to be the last one. That's the right to bear arms.
And the right to bear arms is which amendment?
So that's the Second Amendment, which we will get to.
We're going to go through all of them, gang. So if you didn't get this right, do not worry about it. This was just for fun. What is the Third Amendment about? So Nick, what's the Third Amendment about? Privacy, attorney, jury trial, or is it occupying soldiers?
It's the first one. So it's about soldiers occupying your home without your consent, or as we would have called in the 18th century, quartering of soldiers. Yes.
Awesome. Probably the most we'll talk about it during this year.
Unfortunate to me, but yes, that is likely true.
Okay, so these are big words. So double jeopardy, self-incrimination, and due process are all critical parts of which amendment? Is it the Fourth Amendment, the Fifth Amendment, the First Amendment, or the Eighth?
That would be my favorite number. That's the Fifth Amendment.
Awesome. So Fifth Amendment, those big ones are in there. Yep. The Fifth is fun. It does pop up a lot. And last but not least in our quiz is the original Bill of Rights covered abuses by whom? The national government, the state governments, or both?
And we'll talk a lot about this because it tells us something about the framing of the Bill of Rights itself and the anti-federalist role, but the answer is only the national government, only applied to the national government. And that's why the 14th Amendment is important, we'll get to it.
Yeah, so today it's different, but back then it was only the national government. So I'm going to stop sharing for a second so we can do a quick run through of all of the amendments. So I'm going to stop sharing one thing to start sharing something else. But let's do this. Let's do this. Let's go through these Bill of Rights, starting with the First Amendment. Nick, give us the 10 seconds on each one.
Yeah, so we talk about the 5 freedoms here. So you'll notice that the First Amendment has a lot in it. As we'll see when we talk about the drafting, the First Amendment was kind of a combination of several amendments, not surprisingly, right? Because it covers free exercise of religion, right? And the establishment of religion. So those are the 2 religious freedom clauses, the freedom of speech and the freedom of the press, right? So those are your 2 kind of classic free expression protections. And then there's the right to assemble and to petition the government for redress of grievances. Typically, those are sort of treated as a combination, but we'll talk about these in future classes one by one. So you'll get a nice breakdown of these various rights and why they're all considered so crucial to the liberty of the people.
Yeah, you need to be able to think what you want and say what you want to be able to have all of their liberties. I love those lines, and we will dive into those classes deeply. But let's keep going with the Second Amendment. Yep. So the Second Amendment, a lot of people talk about. Can you break it down for us?
Yeah, so the basic breakdown, right, is we see the 2 parts of it: a well-regulated militia, comma, being necessary to the security of a free state, comma, the right of the people to keep and bear arms shall not be infringed, right? So there's 2 places. Sometimes it's referred to as a prefatory and operatory clause. We get into that when we talk about the Second Amendment. The point here is it's broken down into the parts. We tend to talk about the right to bear arms now. That's the focus of the Second Amendment. But as we talking about in our class in the Second Amendment, that first part of the language, the militia clause, was actually very important in the 18th century because the militia was a state institution.
Awesome. Third, and again, I'm spending a lot of time on third, but go for it.
Well, this is important because of the experience under British occupation, and especially after the 1774 Quartering Act, that allowed British soldiers to forcibly take people's homes and use them so soldiers could stay there, get food, shelter, any of those things, particularly in Boston, which was the key city to the Revolution. And so they didn't forget that experience. This was put in there. Some scholars think of it as not only a piece of federalism, in other words, it's about state power, but also it's a part of privacy. So even if you read the Griswold versus Connecticut opinion, it is one of the amendments that is mentioned that creates the Justice Douglas's penumbras that has to do with this privacy that is in the Bill of Rights.
My favorite, the Fourth Amendment.
Yes, the Fourth Amendment, another amendment that has several protections in it, right? You have to break a lot of these down piece by piece, right? The right of the people to be secure in what? Persons, houses, papers, and effects. We have to define all those things. We talk about that a lot when we do the Fourth Amendment. Against what? Unreasonable searches and seizures. And that shall not be violated unless what? Well, a warrant has to be issued. They can't be issued unless there's probable cause supported by oath or affirmation, and with describing the place to be searched and the things to be seized, right? In other words, the warrant has to be specific. We have to have information we can trust and a specific target. Why? Because there are no general warrants allowed. Because
Don't like general warrants. That's the rule that you will learn in all of our classes. Yep. Can't just make them broad and say anything, anywhere, anytime. That's a no-go because of the Fourth.
That's getting to the heart of our class, and that's why we move on. We get to the heart of what we're going to talk about. You can come back in a couple months, and we'll talk more about it. But for now, that's it.
Yeah, it's a tease. This is the tease class. Okay, Fifth Amendment.
We need a Fifth Amendment class. This is true. Why? Because there's so much going on in the Fifth Amendment. So good. Kerry mentioned a couple of the rights that are in here. So double jeopardy is that language about nor shall any person be subject to the same offense to be twice put in jeopardy of life or limb. Self-incrimination is nor shall be compelled in any criminal case to be a witness against himself. What is due process? It's right there, right? Not to be deprived of life, liberty, or property without due process of law. That's a very important part of the language. But then notice right after it, private property shall not be taken for public use without just compensation. That's eminent domain. That's also in the Fifth Amendment. And you skipped over that first part, which is about grand jury indictments. That's a clause people don't know a lot these days because the public knows a little less about the importance of grand juries. But this was a very important clause in the 18th century. So you see that the Fifth Amendment has a lot in it. And the Sixth Amendment does too. This is another batch of criminal rights protections, right? It's a whole list of them. A speedy and public trial, the right to an impartial jury of the state and district wherein the crime shall have been committed. That's called the vicinage, meaning within the area in which the crime was committed, that's where the jury should be taken from, right? That's where the trial should be. You have to be informed of the nature and cause of the accusation, right? You must know what you've been charged with. You have the right to confront witnesses against you, right? That's called the Confrontation Clause. You have a right to compulsory process for obtaining witnesses, right? And then finally, you have the right to counsel, right? Which has changed meaningfully in the 20th century to include things like the right, if you cannot afford one, right? If you've heard your Miranda rights, a lot of those come from the Sixth Amendment.
Yeah, and the Sixth Amendment always makes it feel like we're trying to make sure our laws, when followed through, are just and fair, and that the person is protected with a just and fair system. Jumping to the Seventh Amendment, this is what we love about the amendments and why we break them down over the course of the year. But walk us through the big idea of the Seventh Amendment.
The big idea is, we'll see, is a lot of anti-federalists complained that one of the problems of the Constitution was that it specifically mentioned the right to a jury trial in criminal cases in the text of Article 3, but did not mention them for non-criminal or civil trials. And they thought that was a real big problem because they thought, well, why should there be a requirement for civil cases, right? In other words, when someone sues somebody else, right? And those can be federal cases, particularly when there's suits between citizens of one state against another. So that's why this was thought to be important. The Eighth Amendment, as we'll see, that goes back to the 17th century. This idea of not only excessive bail, but of course, cruel and unusual punishments cannot be inflicted. That's usually the language most people remember, and we'll probably talk a little bit about where that comes from because it has to do with the origins of the Bill of Rights itself.
And I feel like that's one a lot of students hold on to. They hold on to that one and can see what it means to be and what we've defined.
It's memorable language, right?
Yeah.
Some of this is easier to remember others, unlike the Fifth Amendment.
And maybe they're talking to their teachers about cruel and unusual punishment for homework. Ninth Amendment.
Well, they could give the originalism argument and say it wouldn't have been cruel and unusual in the 18th century.
The teachers can.
You can imagine teaching then, yes. The Ninth Amendment and the 10th Amendment, these last two amendments sort of have to do with, think of it as kind of what's left unsaid, what's left unprotected. We'll get to this as a core problem at the heart of the Bill of Rights debate is whether or not one is necessary, both because of this idea that there's limited powers in the federal government, but also, well, we can't make an exhaustive list of rights. What about the rights we don't mention? Well, the Ninth Amendment is trying to answer that part and say, okay, well, just because we enumerated certain rights, that does not mean that other rights should be denied or disparaged, right? The people themselves retain their rights. A lot of scholars think of this as language that protects natural rights or natural liberty.
I like to say it's a catch-all amendment. So this is like, just because we didn't write it down doesn't mean you still don't have them. So this is like the safety valve catch-all amendment. And then the 10th Amendment, it's really talking about the relationship between the states and the federal government, correct?
Yeah, and I think it's a catch-all for federalism in the sense that it's saying a reminder that the Anti-Federalists wanted that only the powers delegated to the federal government were the ones that they had, and therefore other existing powers were retained by the states and therefore ultimately by the people. Because if you recall, we've talked about popular sovereignty many times. It was thought at the time by many to start with the states and not the federal government as being the most obvious reservoir of the power of the people.
Okay, okay, guys, we just ran you through the 10 amendments. You got the kind of the gist of each one of them. But what we want to do now is we want to kind of say, here's the framing of these, because when we talk about them, we do talk about them as a Bill of Rights, a listing of rights, and we package them together for many reasons. But let's flash back in time to the Constitutional Convention, Nick, and kind of walk us through, how did they get here? Did these listing of rights already exist? Were we the first to ever come up with this brilliant idea to have rights written down to protect the people?
Yeah, so it depends on how we define we. If we still think of ourselves as Anglo or English in that sense.
I'm saying
yes.
Americans.
Of course. This was a history joke based on what Americans thought of themselves as. The idea being that it came from English history and in many ways relatively recent. The Magna Carta is the ultimate origin of many of the rights, or people think of it as an origin. The truth is procedures and rights to some extent existed before 1215, but was the first real charter. It was demanded by the barons of King John when they rebelled against him. But it took centuries to really more finely define these rights. And that really happened in the 17th century, which was a time of great violent unrest, frankly, the time of the English Civil War, and then later the Glorious Revolution. Without getting into a lot of that, toward the end of the 17th century, the Glorious Revolution in 1688 resulted in King James II losing the throne, and parliamentary supremacy, meaning that Parliament, not the king, was the ultimate sovereign in the British government, took control. And what they did is they issued something called the Petition of Right, or I'm sorry, not the Petition of Right, but they issued a Bill of Rights as well is a bill essentially talking about all the ways in which King James had harmed the rights of the people and the rights of the sovereign. And so the Bill of Rights came directly from the abuses of the king himself. So therefore, something like cruel and unusual punishments, which was in the 1689 Bill of Rights in England, was taken from the experience of the king abusing power, that he had essentially persecuted religious dissidents, for instance, and tortured them and falsely accused them. And so therefore, it was experience for them as well that had led to these particular rights being protected. So some of the language that we got for our Bill of Rights was not really changed from where it started with the English experience, right? So that's one important precedent. The other, of course, is the states. We always talk about this because it's important, right? The first constitutions written in this country are not the federal constitution, but the state constitutions. And Virginia gets the head start. Virginia's Constitution and Declaration of Rights are written just before the Declaration of Independence. Thomas Jefferson's aware of it because he's part of the process. And George Mason is the primary force behind the Virginia Declaration of Rights. And
okay. Oh, sorry.
The reason why it's important is because, of course, James Madison, he's very young at the time, but he also knows. And so he is he's able to directly use this Virginia Declaration of Rights to influence the liberties he is thinking about in 1789 when they're drafting a Bill of Rights.
So great question for Milo in the chat. So was Virginia seems to be first a lot. Is it first because it's so big? Why does it tend to be kind of one of the first states to come up with these ideas and move them forward? And then we're going to jump really quickly to the 1860s because I know we have 9 minutes.
Yes. Being big is important for sure. Is one of the largest states. New York is the competitor. Philadelphia is obviously an important city, so is Boston. News at the time, in some ways, travels through ports and through larger cities. So people who have more experience come from there. But I mean, frankly, some of the richest people who have access to this sort of knowledge are also tend to be some of the Virginians. So they're also aware of these precedents. They're lawyers. So, keep in mind that Jefferson, Madison, others, they've studied law. Therefore, they've studied Blackstone, for instance. Blackstone's commentaries, William Blackstone. So they're aware of things like the English Bill of Rights because they've studied it. And so that's where they get from. And I think before we get to the 1860s, we do have to say a couple things about.
That's right. Yeah,
we do have to set this up because it is important to say not only the anti-federalists, but how it is we get this Bill of Rights, right?
Well, here's my question, which I think is fascinating. We get to the Constitutional Convention. They write, 7 articles. They spend an entire sweaty, smelly summer in Philadelphia. There at the end, it's September 17th. They decide, some and some do not decide to sign the Constitution and give it back to the people. But there's no Bill of Rights. That almost feels shocking to me that these are a bunch of people that love their bills of rights in their states, but they don't put it into the Constitution. So kind of explain to us, why isn't it in the Constitution? And then why is it so quickly added afterwards?
Yeah, I mean, it's a great question. We show the dissenters. That's part of it is the last days from September 12th to the 17th. It's basically a handful of those guys, Elbridge Gerry and George Mason primarily, who are trying to get a Bill of Rights added. And so part of why they don't sign is the lack of a Bill of Rights. They try to get it added. Really, everyone's exhausted and they don't want to debate this. And some of the theory is that, look, the states have bills of rights. So therefore, these things are already protected. Well, the anti-federalist response to that is some states do. But what we didn't get to is that not all states passed declarations or bills of rights. Yes, Virginia did. Pennsylvania did. Vermont did. So a lot of states did, but some did not. Federalists said, Well, look, the other states still protect liberties. So what are you talking about? What all we know from experience is actually it doesn't matter whether or not you articulate them. Everyone knows they exist, and therefore they'll be protected. And James Wilson, amongst others, including Madison, Wilson's response was, look, if we have a Bill of Rights, not only do we have a problem of specifying some rights and not others, we have this problem that if you say freedom of speech is protected, it implies that Congress or the federal government had a power to infringe upon freedom of speech or the press in the first place. And we never gave them that power. So why would we do that, right? So that was their response. But the anti-federalists continued this critique, right? When we've talked about the ratification debates, and this was a key part of those debates, was to say the anti-federalists said, well, look, the problem here isn't just that there isn't a Bill of Rights. The problem is we have these competing poles, right? There are states that don't protect it. There are states that do. The federal Constitution actually does have a little bit of a Bill of Rights in it. They talk about this partial Bill of Rights. We've talked about Article 1, Section 9 and 10. That's ex post facto laws. That's habeas corpus. Those are limitations on the states and the federal government. The anti-federalist said is, look, if there's some protections, that implies a problem, right? Because it says there's some limits. But if we don't have these other ones in there for the crucial liberties, won't that destroy states' powers to protect them and threaten the people's liberties as a result?
So just kind of like pulling that together. So at the end of the Constitutional Convention, it goes back to the people, and then you begin this kind of, I don't have a better word to say other than hubbub going around the states, and these debates going back and forth. And from that is the Bill of Rights is the energy behind it. So is it right to say that the Constitution wouldn't have been ratified if there wasn't a strong and like a full promise that we would soon add a Bill of Rights?
I think that's more or less true, because from Massachusetts to Virginia to New York, a lot of these states, as we've talked about, essentially did conditional ratification. They said, look, we're going to ratify the Constitution. We know it's going to happen, but we demand these amendments. We demand a Bill of Rights. And some of them even wanted a second convention. And James Madison and the Federalists said, oh God, we can't have another convention.
No way.
That is the worst idea. Let's just do this Bill of Rights. And from Madison's perspective, he could control that Bill of Rights to some extent, right? Because once they got into Congress, the Federalists had a majority. The Anti-Federalists they lost the first elections badly. And so Madison wrote 17 amendments that got sent to the Senate. You're going to say, well, we only have 10. Well, yes, the Senate threw out 5 of them. We don't know why they rejected them. 12 amendments were ultimately sent to the states. One of them, as we like to talk about, took 203 years to get ratified. That's the 27th Amendment. The other never did. But the first 10 that got ratified by 1791, those were the Bill of Rights. So from 17 to 10. And now just a couple minutes on the 1860s, because it is worth saying why there's this change. There's a lot to get to here. This is why this is hard.
Yeah, it's all right. So we have a Bill of Rights. 1791, we have a Bill of Rights. And that just because we're going to send you guys an advanced Kahoot with a million quiz questions on it. It's going to be really fun. So I want you to listen to all these things. So, at first, the Bill of Rights, it only applies to the federal government. It says the national government cannot abridge your freedom of speech, for example, cannot infringe upon your right to choose your own religion or have a state religion. All these pieces apply to the national or federal government. Fast forward, zoom in our time machine to the Reconstruction time period. So this is the end of the Civil War, 1865, 68 kind of time period. Nick, you'll get the right dates for me. We have the 13th, 14th, and 15th Amendment. So Nick, with these amendments, how does the Bill of Rights change for all people in America?
So I'll just note really quick that Kerry suggested if you read the text of some of those, the Bill of Rights, it suggests that they're applying to the federal government, not the states. That was part of the problem. There's a Supreme Court case. We don't need to really go over it, but it was in 1833. It basically confirmed what a lot of people thought, which was that the Bill of Rights didn't apply to the states. So it did require a Supreme Court case to say that. Well, in the 1860s, we'll talk about this more in future classes. The outcome of the Civil War, of course, brought the 13th Amendment that ended slavery. But the experience of early Reconstruction, of what we call the Black Codes, which were attempts by the Southern states that came back, the former Confederate states, to do everything they could through legal maneuvers to reduce Black Americans to a lower level, right? Something close to slavery. And the response of Republicans in Congress was two things, right? They passed something called the Civil Rights Act of 1866 that covered basic rights, created citizenship as we know it. But then they wanted a 14th Amendment. The reason they wanted an amendment was to make it permanent, right? Both to ensure they had the power to do these things, but also to ensure that it was permanent. And the framer of that amendment, John Bingham, had long thought that the Supreme Court got it wrong in 1833. John Bingham thought, look, the Bill of Rights were supposed to always give us this rule of equality, right? They were supposed to protect all people against any infringement of their rights. It doesn't matter what government did it. That's what he thought. Now, Bingham was probably a minority in that, but he applied it when he framed the 14th Amendment, right? We looked at Section 1, the multiple clauses. We always talk citizenship clause, but we're talking about equal protection, due process, privileges or immunities. He's thinking about specifically through privileges or immunities, the Bill of Rights will now be applied to the states. It's in the Constitution. He thought we've righted a wrong, right? We should have done this before. They screwed it up, but you know what? We're going to do it now. It's now permanent, and now we apply it to the states, which means that the federal government is a guarantor of the rights when states violate them of citizens of the United States.
I love John Bingham. My side running joke of John Bingham is he looks exactly like the guy in Poltergeist, but that's just to
Right.
make you remember him. But one of the things I want you guys to check out, and I'll send you in a link, is the drafting table. You can actually see John Bingham's words around it and what he wanted to put in there. So incorporation, we talk a lot about the Bill of Rights being applied to the individual. I like to say that this is like the sticking amendment, that it takes the Bill of Rights and now the Bill of Rights sticks to the individual and not just the national government, that it's about you and what you're protected on. Now, I want to fast forward, Nick, because we have 1 minute left, to the hypothetical modern question, because this is happening right now, everybody. And like, you can see it in the streets, you can see it in our churches all around the country with COVID, and what happens around this listing of rights in time of a pandemic, in time of an election, all these pieces. So here's your hypothetical. The Supreme Court has heard several recent cases about the treatment of religious services under lockdown orders. The argument is that though the 14th Amendment and the Equal Protection Clause, religious services and churches cannot be treated differently from other businesses without a good reason. So do you think this is acceptable, non-acceptable? Kind of like, where do you all sit? Where do you think it's okay if the government says, no, you can't have church, you can't have the freedom to assemble, or yes, in time of COVID, we should do that? You guys can just answer in the chat box. Milo is going, yes, you can restrict. I'll wait for a couple others.
I think you mean the opposite for the second part, Kerry. You mean that they cannot restrict, that these protections still apply despite different circumstances, right? Because that's essentially the argument is, yes, they're extenuating circumstances, but the constitutional text still applies.
Yes.
And even if we understand the Supreme Court correctly in terms of giving more states leeway, ultimately, there's still limitations.
There's still limitations,
yes.
And everybody's coming in. You can encourage it, but you cannot restrict. They apply. I think that it's against your rights, Charlie. Nice one, Charlie. So kind of where do we sit in this? Because it's not a yes or no answer. It's not just black and white. So can a state restrict people from attending a church service in time of COVID? Is the answer yes or no? And then what are the kind of the particulars around it, Nick?
Yeah, so I mean, you kind of suggested, right, that it depends. And so the answer here, and this includes what the Supreme Court has said on it this summer, which is, well, it depends on how long. Duration's important. If this is a short limitation according to emergency circumstances at the time, then yes, but that might change. And it may have changed by this point. If we kind of read between the lines. What that also tells us is that it's a close question. because what's important here is, are religious services treated different from other businesses? And if they are treated different, are there good reasons that are given? Or does the state just do it because they can do it, which would be a problem under the Bill of Rights? Because the other thing, as I suggested there, right, is yes, the states have extensive powers. We talk about what are called police powers, which is, public safety, health, and morals. They can regulate those things. But there are limitations, right? Which is, if they try to do this for too long, if they show animus against a particular religion or a particular people or group of people, whether, say, it's Orthodox Jews or like people who work at a movie theater, you can't do that if you don't have a good reason, right? And that test essentially still applies. So you think of it as a scale, right? Is COVID might slide that scale a little bit, but it also depends on how long and how they're treating different groups differently, especially when we're talking about religious liberty.
Yeah, and I think these are fascinating ones to look at. And next, if we host this class every Monday, Wednesday, and Friday, and we're going to switch the question up each day, just in case you join us twice. I want you to have different questions on different days to keep you on your toes. So that is going to be a wrap up of our Bill of Rights class. So there's a lot in the Bill of Rights, understanding why it was originally written to ensure that the federal government could not step on the states or the people, how the 14th Amendment changes it during the end of the Civil War and the Reconstruction time period, and then how the application happens today in times of pandemics, in times of protest, in times of elections. All this stuff keeps these amendments so modern and so crucial to our conversations. So I want to thank everybody so much. We will be doing an advanced Kahoot and sending it out to you all if you want to play the game and see how at the end of the week you answer all these questions. But after class, we're going to hold for 5 minutes if you want to join us for any election-related questions. So Nick, I want to thank you so much for class today, and everybody else who needs to jump, we'll see you in class next time.
All right, bye.
Don't leave, Nick.
I know, I'm not leaving. I'm not going anywhere.